morning, everyone. We're going to go ahead and get started. Ms. Linker, would you like to take the roll?
Commissioner Cardenas?
I am here.
Commissioner Hayward?
Here.
Commissioner Wilson?
Here.
Chair Matich?
Here. All right, we'll begin with public comment for any items not on the agenda. Mr. Vaughn, welcome back.
I obviously provided the information for public comment already, so I just wanted to come today to reiterate those facts a little bit. First of all, I wanted to say thank you for passing the regulation that you did in December. I wasn't able to attend for the discussion. I know it was late in the afternoon. And I wanted to thank Commissioner Cardenas for raising the concerns about the appropriate size for the exemption for allowing someone not to publicly disclose a financial interest. And I would make the point when I bring that up that I think it's incumbent upon the commission to define what that is, since in the instance where I brought up with Supervisor Euler's wife, she was one of 13 people out of 2,500 employees, which is 0.5% of the population of their employees, and that was enough for her to be given an exemption for disclosure and her $30,000 raise. I know council said that they've set it down to one person, but I think there's somewhere in there that 1 out of 2,500 would probably be a little bit too small. You know, 2 out of 2,500, in my opinion. Secondly, I'd like to bring to point that while you have made your decision that the raise and Supervisor Euler's lack of disclosure were exempted based on this small amount of people, the county can't have it both ways. I currently have a sworn complaint for a 1090 because Mrs. Euler has been acting as the director, as you know, of Child Support Services, and your 1090 letter, advice letter, noted that she couldn't be given substantial duties or additional responsibilities while Supervisor Euler was in office. So the county cannot have it both ways. They cannot say that she is supervising attorneys when it's not in her job specification and give her a $30,000 raise because of it, and also say that, you know, she has not received any additional duties. So I'm just asking that the commission, I know that I've been delayed. I did get a response back that you would take additional time to review the case, but I would just ask that you take this into serious consideration on these 2 sworn complaints. And I want to thank you for your time.
Thank you. The record may now reflect that Commissioner Hatch has joined us. Commissioner Hatch, how are you doing? All right. Is there any further public comment in person on items not on the agenda?
Yes.
All right.
Yeah. Do I need to fill out a form for that or no?
No.
Okay. I have an item that is on the agenda later, but it's not directly related to the comments here. My name's Chris Stampolis, and about 18 months ago, I submitted a sworn complaint to the FPPC. I brought copies to, not of the complaint, but of the letter back from Ms. West acknowledging the receipt. I wanted to bring it up here because of the timeliness with regard to what's happening in the political world right now. The complaint was with regard to about $90,000 of concealed money, somewhat of a whistleblower complaint from Tom Steyer with his organization NextGen, deliberately meant to circumvent the limits with regard to donations to the California Democratic Party. The recipient, Carlos Alcala, and his wife used the money personally for their own family, and that was actually provided, with clear documentation in the complaint. The letter back from Ms. West was dated September 11, 2018. In the very most recent electronic newsletter from the organization that was the recipient of the money, they're clearly shown online with Mr. Steyer celebrating and doing political campaigning with the same people that received this $90,000 of money. So I would say that either hopefully the commission can finish its investigation and either find out, hey, maybe there's nothing there and exonerate them, or go ahead and hopefully they're actually taking some type of action. But the date here was September 11, 2018. It's been an awful long time with no action at all. So I'm going to go ahead and I have my letters here maybe just to be distributed, if I may. Thank you.
All right. Thank you. Do we have other public comment on items not on the agenda? All right. Seeing none, We're then going to take one item out of order. Item 15 is a closed session administrative adjudication by the commission. This is in the matter of Chris Stampolis, Friends of Chris Stampolis for Santa Clara School Board 2012, and Chris Stampolis, FPPC number 15/1045, OAH number 2019-01677. To begin with, we will have the parties present oral argument. Each side will be afforded 5 minutes. They may reserve up to 2 minutes each for rebuttal. So we'll go ahead and call item 15 at this time. Good morning. Go ahead and introduce yourself.
Good morning, Chair Matich and Commissioners. My name is Ruth Yang, Commission Counsel with the Enforcement Division.
All right. Good morning. Do you wish to reserve any time for rebuttal?
I would like to reserve 2 minutes for rebuttal, please.
All right. So you have 3 minutes. Please proceed.
I'm here to speak in support of the proposed decision that was issued in the matter of Friends of Chris Stampolis for Santa Clara School Board 2012, and Chris Stampolis. The Enforcement Division requests that the Commission make technical and minor changes in the proposed decision issued by Administrative Law Judge Juliet Cox, and then adopt that decision. Mr. Stampolis was an unsuccessful candidate in the West Valley Mission College Board in the November 8th, 2016 general election. At that time, Mr. Stampolis had 2 candidate-controlled committees open. The Political Reform Act requires committees to periodically make disclosures of their campaign activities and pay $50 annual fees for every year that the committees are open. These are basic requirements that Mr. Stampolis and his committees had failed to execute in a timely manner. As a result, the administrative law judge made a finding on all counts, namely for failure to timely file semi-annual campaign statements, failure to timely file pre-election campaign statements, and failure to timely pay $50 annual fees. The administrative law judge proposed a $9,500 total penalty for all counts. After considering the evidence, mitigating factors, and aggravating factors present in this case, the Enforcement Division believes that this is a fair conclusion. As a result, the Enforcement Division respectfully requests that the Commission make the technical and minor changes and then adopt the decision. Thank you for your time.
Thank you. Commissioners have any questions from the opening argument by enforcement staff? All right. Seeing none, this time I'd like to invite Mr. Stampolis to the podium to present his opening remarks. Do you wish to reserve any rebuttal time?
I would also like to reserve at least between 1 and 2 minutes for rebuttal.
Okay.
Okay, yeah, I'll reserve between 1 and 2 minutes for rebuttal. Thank you. I'd want to point out that the administrative law judge did make 2 findings of fact that I think are very relevant to this case, and that is that my defenses were not frivolous. On one of them, although she disagreed, I will respond to that briefly. On the second one, she believed that she had no jurisdiction to make a finding. But I think it's very pertinent that my perspective and what I presented was actually seen to have at least merit for being considered. On the first issue, with regard to the technicalities and the due process, the FPPC's enabling language in the state code specifically says that everybody is entitled to equal protection under the law. In this case, I believe I have not fully received my equal protection. The probable cause conference that occurred on September 18, 2019 was held before Jack Woodside. However, FPPC documentation presented here to this commission at its meeting of February 2018, line item 22, slide 26, on the website currently now, and not in any way contravened since that presentation, specifically states that anybody having a probable cause conference has the right to request an administrative law judge hold that conference. The administrative law judge at the hearing specifically acknowledged that that occurred and that the FPPC denied my opportunity to do that. I did provide a copy of that slide and that documentation to the administrative law judge at that time. So my first request would be that this be remanded back so that formal process can be done, because it did deny me rights as well as having a reasonable opportunity to have counsel at the administrative law hearing, because I thought it would clearly be noted that I didn't get my administrative law judge and that it would be sent back. Second, with regard to the second portion of the charges, which have to do with not paying the fees to the Secretary of State, there are two items there that I had brought up. The administrative law judge only referred to one of them, and she said that she did not have jurisdiction over that. I have contended that this is a constitutional violation with regard to restraint on free speech. I have contended that for many years, and she believed that she could not come to a conclusion on that perspective. So I believe that the FPPC should either rule on that or again remand that for further consideration. Finally, with regard to the content that's here, the current streamlined guidelines for amount of penalties specifically show significantly lower amounts of money than what is being proposed here as fines. Every one of these items that's before us was a local originated issue. The total amount of money raised and expended during the entirety of all these charges was $0. Not just below $2,000, but zero. The streamlined offers are significantly lower than what should be provided here.
Thank you. That was 3 minutes, Ms. Linker?
3.5 minutes.
3.5. Mr. Stampoulos, do you want to take another 30 seconds and reserve a minute for rebuttal, or do you want to reserve the full 1.5 minutes for rebuttal?
I guess as long as I'm not waiving my minute and 30 seconds, if council chooses not to comment, then I will reserve.
So you're reserving for rebuttal? Yes. Thank you. Ms. Yang.
As to the equal protection argument presented by Mr. Stampoulos, the Enforcement Division does not have any record of such a request being made. We only received a request for a PC conference, and we did provide that with Mr. Jack Woodside standing as hearing officer for the agency. As for the annual fees, the constitutional violation argument, that I do not believe that is something that the Enforcement Division can answer. I will leave it to the legal division to speak on whether or not the commission has jurisdiction over that as well. As for the streamlined matter, we are beyond the point where a streamlined program is appropriate for this case, and so that is why we went to administrative hearing, and we are proposing that the commission accept the proposed decision that had been issued with the technical and minor changes.
Can you expound on the point about streamline a little bit more? Why is it that this particular matter didn't qualify for streamline?
It is not that it did not qualify. It is that we are at a stage far beyond where a streamlined program is appropriate. We usually
Galena West, Chief of Enforcement. With Streamline, there has to be a level of cooperation, and there has to be an agreement to the facts as well as the penalty amount, and in that was not reached.
Thank you very much. Do you have any further remarks?
No, thank you.
Commissioners? All right. Mr.
Sure.
Stampoulos, you have a minute and a half.
With regard to what Ms. West said with no cooperation, I'd say the facts show exactly the opposite. There were no documents ever left unfiled. The first two of these charges on here actually were completely resolved before any contact from the FPPC. The streamline says that the maximum is $200 per violation if it's resolved with after the first contact. In both cases, they were resolved before any contact. And in the second of the cases, there was a formal letter from the FPPC closing the closing these. I never had any communication at all with regard to streamlined settlements. The settlement information that was provided to me was significantly higher than what the current amounts are from the administrative law judge, and so of course I never accepted those. And when they came to the administrative law hearing, they asked for $3,000 per count for a $0 money raised. In all cases, everybody acknowledging that a Form 470 was filed. Ms. Yang continued to try to convince the administrative law judge that the public had no idea what I was going to be raising during that campaign cycle. They specifically withheld the Form 470. I had to go get it certified by the County of Santa Clara. I brought it to the ALJ hearing. It was admitted over Ms. Yang's objection to prove that I had filed the 470. So from day one all the way through, for what reason, I don't know, this has been a very targeted, a lot of money spent from the FPPC. All the documents show there's no intent to conceal at all. No money raised, every document filed. And so I ask that the commission take that significantly under consideration in terms of any final decision. And I would say the final thing to mention also is that in terms of the local races, the statute is very clear that if a county registrar wishes to impose any fine, they are limited to $100 in cases where no money is raised. And that in this case, these have been referred by the county up here on a subjective decision at the county level. The reason why that's important is that that $100 should continue to bind over. The larger amounts should be limited to state committees that have no responsibility to file at the local level. Otherwise, you would be saying that local committees get 2 fines and state committees, which are much larger, only get 1. Thank you.
Very much, Mr. Sempoulos. Any commissioner comments at this time? All right. At this time, the commission will adjourn into closed session to deliberate. All right, we'll go ahead and commence again out of closed session. In closed session, the commission considered the matter of Chris Stampolis et al. The commission has decided to adopt the administrative law judge's decision with two caveats. The first is we'll be making some minor and technical changes to reflect citations that were incorrect in the ALJ's proposed decision. Secondly, with respect to counts 1 and 11, the commission is reducing the proposed fine amounts from $500 each to $0 each. In all other respects, the commission, or the administrative law judge's proposed decision is being adopted by the commission. We'll now move to item 2 in the agenda, approval of the December 2019 commission hearing minutes. Do any commissioners have any edits or comments on the meeting minutes? Hearing none, do we have a motion?
Move approval.
Ms. Lincoln?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Moving to the next item, our enforcement consent calendar. This is items 3 through 5. Do any commissioners have items that they wish to pull from the consent calendar? Seeing none. Is there any public comment on items 3 through 5? Seeing none. Any commissioner comments on items 3 through 5? Seeing none. Do we have a motion to approve?
So moved.
Second.
Ms. Lincoln?
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Moving to items 6 and 7, these are both matters for which they're enforcement matters which will be referred to an administrative law judge unless two commissioners request that the commission hear these matters themselves in the first instance. With respect to both items 6 and 7, it's my view that the commission should consider hearing both matters ourselves as opposed to asking an ALJ to hear those. So that's my view. Do we have commissioner comments on that?
Yes, I, for different reasons, think that we would profit greatly from hearing both of these ourselves.
Yeah, I would concur. If the chair wants to remove these items and hear them, I would be in approval.
All right. Commissioner Hatch?
That's fine with me.
Commissioner Cardenas, any comments on items 6 and 7?
I concur with the chair. Thank you.
All right. Is there any public comment on items 6 and 7? All right. Seeing none, General Counsel Bainbridge, my understanding is we don't need to take a formal vote because it's sufficient that two commissioners are requesting that we hear these ourselves, but correct me if I'm wrong.
I would recommend taking a vote.
Fair enough. I would move that the commission hear items 6 and 7 ourselves instead of having an administrative law judge hear those matters, and that staff be directed to schedule those matters for the commission to do so. Do I have a second?
Second.
Ms. Linker?
Just a question, if I could. Is there, as a class, a special reason why we would pick these two out over the others we've seen in the past that we did take to ALJ? Is it, in your view?
In my view, particularly with matter number 6, in the matter of the city of Fountain Valley, that matter involves allegations that the local jurisdiction used public funds for campaign or political purposes, which is an area of emphasis for the commission. And I think it would be beneficial for the commissioners to hear such a case in the first instance, given our interest in that subject matter. With respect to item 7, I think that is based on the description that we have here, I think that's in the staff memo, I think that is a good case for the commission to hear to gain some exposure in how our staff presents cases and how respondents argue in response to that. So it's good exposure for the commission to an administrative law proceeding.
Thank you.
With that, we have a motion and a second.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Aye.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. Moving to item 8, update on the task force for digital campaign activity. On this, this is simply a report that Commissioner Hayward and I and Executive Director Jones will be going to the state of Washington later today for a meeting tomorrow with the Washington Public Disclosure Commission to talk about the issue of enhancing disclosure of campaign activity on social media and other topics, which is consistent with what we had announced that we wanted to look at. Incidentally, we also have received feedback that at least one member of the Federal Elections Commission is interested in perhaps working with us or partnering with us as we explore this area. So hopefully we'll have more to report on at a future meeting. Commissioner Hayward, anything?
Road trip, no.
All right. Moving along then to item number 9. This is our budget process report back. There were some questions raised at the December meeting about the budget process and information provided to commissioners. So this is a report back. Executive Director Jones and Chief of Admin Hahn will be leading our discussion.
Thank you, Mr. Chair. There was a request at the conclusion of last meeting with respect to the budget process. Administrative Director Hahn has put together a memo both with a description of the process and also a proposed timeline going forward so that we can, at the staff level, make sure that the commission is adequately informed and involved at each stage of the process going forward.
Anything further?
I guess at this point, I can ask Division Head Hahn to go through the memo itself, but we're also open to hearing from the commissioners if there's an immediate response to the proposal.
All right. Ms. Hahn, do you have anything in particular you want to draw our attention to? If not, we'll open it up to commissioner comments.
Not at this time. I will take any question the commissioner might have.
All right, thank you. Do any commissioners have questions?
I don't know if this is a question or an observation, but, unlike some boards and commissions and departments, we don't build things, we don't decommission nuclear power plants, we don't do lots of expensive capital stuff, right? We basically have people, and we pay them salaries, and we pay them benefits, and we have, copying machines and some travel stuff. But it's pretty much, that's what we spend our money on. And so I guess, looking at the current or the recent history of the agency, the one time we get sort of backed up against a wall is if something unexpected happens with regard to compensation, like, for example, somebody with years and years of seniority and years of, owed payout for vacation retires. And they're with us instead of with the agency that they worked in for 25 years. And so we're the people who, you got to let people retire. There's not exactly, we don't really have a remedy that way. Is there, forward-looking, is there a way of reducing that risk or budgeting for it or something because we're hit at a time that was also bad economically, and that was something that took some years to bounce back from. Is there an answer to this?
The answer is that Cal HR have put out orders and policies requiring State Department to require the employee that have a certain number of, exceeded certain number of hours to have a vacation plan to burn it down to the max limit, which is 640 hours. And we have done it the last couple of years when people here, employee here, that exceeded the 640 hours to provide HR with a plan how they could burn it down. And we would have to keep watch on those. So, and as far as if someone here has somewhere around 640 hours when they retire, every state agency is dealing with that, so there's nothing more you could do. But for those who are exceeded 640 hours, so we just have to keep reminding them that you need to burn it down, you need to keep taking vacation, or have a plan for us, like maybe take every Friday off so you could get to the 640.
Thank you.
Any other commissioner comments? All right, any public comment on this item? Seeing none? All right, thank you, Ms. Hahn. Thank you, Executive Director Jones.
Thank you.
All right, we'll move on to our item number 10, the governor's budget. Chief of Admin Hahn, back on.
So the memo it speaks for itself. This is the funding that we're going to get allocated for fiscal year 2020 and 2021. And like Commissioner Hayward said, we have a baseline budget that has to do with staff salary, staff benefits, and operation costs, such as rent, IT costs, things of that sort. So this is our base for the next fiscal year. It's $15 million. Approximately, and which included what we went over and asked for legislation, which is AB 571, and that would give us $932,000. So here's my presentation. If there's a memo, if you have any question, I would be able to hopefully answer at this time.
With regard to the $932,000 you just mentioned for AB 571, what does that translate to in terms of number of positions? First question. And secondly, when do we anticipate hiring into those positions?
So the $932,000 would give us 6 positions, 4 in enforcement division, 2 in the legal divisions. And the authority comes into us on July 1st, 2020, so we'll be able to hire after July 1st of 2020.
Thank you. Other commissioner questions?
Yes.
Sorry, go ahead. No, after you.
Chief of Admin Hahn, this is more of a technical question.
Yes.
At the last commission hearing, it's my understanding we have about 80 members on the staff. Generally speaking, what is the vacancy rate in a given year?
For the last 4 years that I've been preparing a budget, our vacancy rate is average about 15%.
Oh, okay. All right, thank you.
Commissioner Hatch?
Yes, just to follow up on the question I think I've raised in the past about these advice letters that we're required to give by the legislature on the, it's funny, I can't remember the code section, the government code section relating to
1090?
1090, yeah, thank you. I know that it's been some time since the legislature piled that on us, but we've seen a steady increase in the volume of 1090 letter requests relative to the normal requests that we've always been under. Was there any attempt this year to try and make a budget change proposal request to compensate us going forward on this increased workload that was a result of that legislation?
So the past fall is when we have opportunity to do budget change proposal, and we did not do that for the purpose of 1090. We only did a budget change proposal that's related to legislations.
legislation, yeah.
Yes. And the annual, later on the agenda, there is a report that we provide to the legislature based on the request, looking at our workload metrics, and you'll see the historic on that agenda items, what we've done for 1090 and how the consistent workload of increase that you're speaking to.
Well, I just strongly urge that this be made a priority to try and develop the data that you can make a request. I know this is like a long time since the horse is out of the barn, but nonetheless, the legislature required to take on this responsibility without any idea how much workload that was going to impose on us, and we didn't know at the time either. And now we're really finding it's biting. I think the last month, I think it was 1090 letters were almost equal to the other letters, and that's a lot of workload because they're very complicated advice letters. Thank you, Mr. Chair.
Any other commissioner questions or comments? Any public comment on this item? All right, seeing none. Thank you, Ms. Hahn. Moving to item 11, this is our legislative update. Welcome to the table, Mr. Ung.
Thank you, Chair Matich. Commissioners, Happy New Year. The legislature has returned back to session, and before you are two items under Agenda Item 11. One is the legislative update, and the other is the legislative development. As far as the legislative update memo, it speaks for itself. The legislature has not introduced any new legislation so far in January, although I expect that in the February report that may change. I have included in the legislative report all of the bills that are still active that are related to the Political Reform Act. I do want to make a verbal update as to one bill that's not on your written memo that we thought was dead but was revived earlier this week and then subsequently died this morning. But it's Assembly Bill 1245 by Assemblymember Lowe, and that bill would have prohibited all business entities from making direct contributions to candidates in the state of California. Last year, that bill was introduced. It was heard in the Assembly Elections Committee. It received a motion in that committee, but not a second, and so it was held in committee for lack of a second. This morning, or earlier this week, Assemblymember Lowe asked that the committee hear it again at their hearing this morning. This morning, it was a vote-only bill, and the same result, it got a motion from Mr. Lowe, who is a member of the committee, and did not receive a second. So that bill was held again, and I believe that particular bill, AB 1245, should be dead for this session because the deadline to move any first-year bills out of the House of Origin is this Friday. And so my apologies for not putting that in your memo. I just heard about it yesterday, and so I wanted to make sure that you were updated on the going-ons on that particular policy. I'm happy to take any questions you may have in regards to the general legislative update. Attached to that update is the legislative calendar, which I think last year you found helpful in helping you navigate the legislative process. I think this year we have help from Commissioner Wilson, who could potentially help us if we have any further questions about the calendar or process. But happy to take any questions about the general legislative report. And if there are none, I'm happy to move on to the legislative development update.
I'll just say you're so efficient, there's nothing I could add.
Thank you, Commissioner.
All right, go ahead and proceed, Mr.
Okay. Thank you, thank you, Chair Matich. As far as legislative development, at the direction of the commission, staff did send a number of requests to Legislative Council to have drafted in Legislative Council form. We have received most of those requests back. However, staff has not had a chance to review them in detail. As I mentioned last month, when you send requests to Legislative Council, sometimes they come back exactly how you drafted them and exactly the intent in which you drafted them. Sometimes they come back different. And so we just need to review the proposals that have come back. I can tell you that from some of the early discussions that I've had with legislative offices, just in concept, many legislative offices are interested in some of these bills that the commission is interested in sponsoring. And so that's optimistic that we've heard some early kind of bites on the legislation that you are wishing to pursue. One of the things that is not on your legislative development report that has come up since December or late December, early this month, is that as you may know, last year the legislature passed Assembly Bill 571 by Mr. Mullen, which dealt with local default contribution limits. The bill would essentially apply a contribution limit to any local city or county that didn't have their own contribution limits. Since that bill was approved and signed by the governor, the staff has identified multiple interpretive issues with that legislation. There are three that I wish to highlight today. Whether the default contribution limits apply to California judges. Judges are state officers, but they are elected at a county level, and so there is some question as to how a default limit may or may not apply to them. The second issue is how a default contribution limit would apply to jurisdictions with voluntary contribution limits, where local candidates opt into that contribution limit. And the third issue is the need to clarify how default contribution limits apply to jurisdictions where there are mandatory contribution limits, but only on some of the elected officers and not others. One immediate example is here in the county of Sacramento. The Board of Supervisors has a contribution limit, but the sheriff and the DA do not. And so there is some question as to how the default would apply to the county of Sacramento and those officers. And so I provide this update not as a sponsorship request, but we've been in contact with Assemblymember about these issues, and I think staff is hoping just to raise these issues to see if there's any objection from the commission with about staff continuing that conversation and pursuing these cleanup issues that we've identified with Mr. Mullen.
You're looking for legislative solutions on these questions that you just raised?
It appears that for these three issues, we would need a legislative cleanup bill, yeah.
Is it your understanding, Mr. Young, that the overarching purpose of 571 was to fill the gap, so to speak, where there are local races where there wouldn't otherwise be contribution limits? And so we said essentially default state limits that would exist unless the local government took action affirmatively to impose limits?
That's correct, yeah.
All right. And then the second question I have is with respect to judges, the fiscal analysis that I think we worked on with respect to that bill, did that include or contemplate that judges would be included in the scope of this bill?
It was not, no.
All right. My sense is, and looking for feedback from my colleagues, that we should work with the author to address these questions about the bill in terms of implementation. But we should do that consistent with an understanding that the intent was to fill this gap. So I wouldn't want a solution where we interpret the bill such that there would continue to be gaps in local races
Of course.
that wouldn't otherwise exist. And secondly, an interpretation that's consistent with our, at least, understanding from last year that judges were not within the scope of this particular bill.
Correct.
On the example that you gave about the sheriff and one other officer, that they imposed, self-imposed limits on other offices, but not those two. It would seem to me that there's a clear intent that they didn't want to have limits on those. I'm not sure that we would want to legislatively tinker. If they had not acted at all, I could see, sure, okay, they're on the default of the state limits, but I'm not sure that we would want to play mischief of saying, well, if you let some people off the hook, we're going to construe that to mean that you didn't establish any limits and therefore you're under the default. It's something I think we should kind of think through before we decide which direction we want to push on that legislatively.
Do other commissioners have feelings on that?
As we all know, I don't like limits. And I guess I would echo Commissioner Hatch in that, I think it is, if a jurisdiction has positively chosen not to limit contributions to some officials and limited them to others, then we should respect that local jurisdiction's decision that way and not try to shoehorn in a limit that, when written for statewide officers and legislators, was written for vastly larger districts than what you would see if, say, you're applying those limits to a community service district or, a abatement, vector abatement control district or something like that. I just think 571 was a bad idea. But let's defer to local office holders' decisions on what they want to be governed by when it looks like they've made a decision that way.
Mr. Chair, to respond briefly to the comment of what Commissioner Hatch said, I think that's the interpretive issue that we're hoping to have cleaned up. When you read the legislation, we're not sure yet whether or not they meant to apply it jurisdictionally or to candidates. Because Sacramento County has a contribution limit for the jurisdiction, and so there's one interpretation that, well, they've adopted one, so the commission's default would not apply. Right. There's another interpretation in a couple of provisions of the bill where it talks specifically about candidates being subject to these limits. Mm-hmm. And so there's a question of whether or not that default kind of sifts through and applies. And so we would just need that clarification. And when we've reached out to the author, they had a third interpretation that we definitely did not read into the bill. And so we immediately said we need some legislation to get this cleared up because it.
When we heard this in the committee and made a recommendation to support, it was with the understanding that this would be only apply in cases where they had not adopted any limits at all, and that they would be free subsequently to adopt their own limits, to take themselves back out of the default. You know, this is sort of this carrot and the stick approach. So it just doesn't feel right to me that we would play gotcha and say, well, if you imposed it on some but not all, therefore we're going to pick and choose, you know, and make it very difficult to enforce. On the other issue of the judges, they are state officers, and I'm not sure that we should treat them like local officers if the law says they're state officers. So they may be just outside the fray of this. It'd be up to the legislature to decide what, if any, contribution limits apply to judges.
Yeah, I think of the three issues, the judges one's probably the easiest to answer. That we might be able to do that through interpretation here at the agency. But I know that was an issue that was raised by Mr. Mullen in our conversations, so.
Okay, thank you.
Commissioner Wilson, any comments? No. All right. Mr. Ryan, I think you have direction to work with the author on that. Anything else for us?
That is all I have unless there are any other questions from the commission.
Yeah, the commission. Any public comment on this matter? All right. Seeing none, thank you very much. All right, moving to item 12. This is a follow-up discussion for the commission on enforcement priorities and processes. As a reminder, in November, Chief of Enforcement West did a very thorough presentation to the commission on enforcement processes and priorities. And so following up on that, which I think was very, very helpful information, I wanted to begin a conversation with the commissioners on at least three areas with an eye towards developing consensus around some concrete proposals for purposes of the enforcement regulations, which we currently have slated to pre-notice in June. So this is the first of many conversations probably on this issue. The first area that I'd like the commissioners to discuss today are what would be the 2020 enforcement case priorities. And the idea is I'd like for us to give some guidance to enforcement on which areas we want them to focus on this year, 2020 election year. And so those areas, in my view, I think the commission should consider giving direction that they prioritize time-sensitive campaign cases where the violation relates to a lack of pre-election public disclosure of information required under the act. So that'd be the first category of cases. And within that, I would sort of broadly include ad disclaimers, pre-election reports, 24-hour reports, and over the limit or other impermissible contributions, again, that are time-sensitive and relate to one of the pending elections that we have this year. The second category would be money laundering. The third, misuse of campaign funds. And the fourth category, the misuse of public funds for election-related purposes. And to be clear, these would be the areas that staff would prioritize this year. Does not mean the staff is not going to continue enforcing every aspect of the act. That should be clear. Of course, we're going to do that, but these are the priorities given our limited resources for the election year. Do commissioners have comments or reaction to that?
Just to question the first one, is this like a fast-track calendar for certain, is that the idea, for certain types of things that are ongoing during the election?
No, the idea is to give the Chief of Enforcement direction on, given her limited resources, which cases we would like to see her focus on in the election year. Well, whether they're resolved through streamline or mainline remains to be seen. So these are conceptually, these are the areas we want to focus on.
I would like to add an additional category, if I could, for you to consider. And that is that now that we've dramatically improved the case management with the expanded streamline program, I'd like to see a dividend here in the sense that you'd be able to target what I'd call euphemistically intentional behavior and go big game hunting a little bit. And I'm not going to tell you what to do, but I'd like you to maybe come back with us, in your view, what you think is possible to do within the resources. I know my gut is that by using the expanded streamline program, we've perhaps freed up some additional opportunities to put, I know these kind of cases I'm talking about are pretty labor intensive, so that you may not be able to do more than one or two in a budget cycle, but I'd like to see something from that direction.
Chief Enforcement West, is that something that your staff already does, is prioritize clearly intentional violations of the act?
Yes, Galena West, Chief of Enforcement. One of the things in my presentation in November was one of the projects that we have ongoing is a proactive laundering program where we look at jurisdictions, we narrow them down, we analyze the campaign statements, then get the records, and it's a very time-consuming process, and I believe you'll start seeing some dividends to that this year.
And I'm very strongly in support of money laundering cases, but I consider that sort of a subset of what I'm talking about. Intentional behavior can be, fudging the deadlines to try and avoid disclosure and all manner of things that are routinely done over the decades to, get an advantage without disclosure to the public what they're doing. So
I completely agree. One of the other things that we do is try to keep up on the media reports for the people supporting and opposing what the ballot measures are for November, so that we can see if the disclosures actually reflect the same people or if there's some non-disclosure going on there through some funny business. So that's something that we'll be focusing on as we go through this year.
great, thank you.
Any other commissioner comments on priorities for 2020? All right. Moving on to the second category that I wanted to talk about today. At the last meeting and also during the November presentation, there were some questions, some information provided to us on the criteria and the factors that enforcement uses with respect to mainline cases and resolving mainline case stipulations. As you pointed out, Chief Enforcement West, the criteria that you apply include the criteria that by regulation apply to the commission when the commission considers cases. And so you have used those criteria, and they're in Regulation 18361.5, subdivision D. You use those with respect to mainline cases. The regulation doesn't specifically direct that. So I think first and foremost, I would like the commission to consider giving you, some clear indication that we support you using those guidelines, even though the regulation doesn't strictly require it, and give some thought to amending the reg to make it clear that those are the criteria that we want you to be using going forward, with at least two caveats. The first is I notice in your stipulations you include two additional criteria that aren't strictly speaking in the regulations. Those are comparable cases and also sophistication of the parties. I think, in my own view, that those criteria make a lot of sense. And so I think, again, as the commission thinks about this, we ought to add those to the criteria that are in our existing regulations, because they do reflect what the practices that you're currently using. I think they provide good information. Secondly, the current regulation begins with one of the criteria is seriousness of the violation, but it's followed by a number of other criteria which seem to subsume that concept. So the presence or absence of intent. So I think that gets to Commissioner Hatch's point that, intent to conceal or intent to deceive should be a factor that we consider, or the deliberate versus negligent or inadvertent nature of it. Those are things. And I think those go to the concept of seriousness. And so I think as we move forward, considering whether or not seriousness of the violation is a standalone criteria makes a lot of sense, or whether what we're really trying to get to there is more of an issue of the degree of public harm, so to speak. So whether that is the information that perhaps wasn't disclosed is available in other places, or the age of the case, whether the person is still in office or not. So I think the commission, as we consider this over the next few months, should consider whether that particular criteria could be refined and become a little bit clearer. So those are my comments on what I think we should focus on in terms of criteria for mainline cases. I don't know if other commissioners have comments on that.
I tend to agree. I think you pretty much hit all the humps that I was thinking about.
All right.
I would agree with the chair. I do have one question, though. Whether a repeat offender is someone who you give greater focus to, just from a practical standpoint.
Certainly. We use isolated or part of a pattern and prior record of violations of the act or similar laws are two of the criteria that we focus on. And we use those and weigh it heavily if you've done this exact same thing. It's also why you would not get streamline again if you can't file your statements correctly or on time, and the next time you wouldn't qualify for streamline if you've already gotten a streamline penalty.
Chief of Enforcement West, thank you.
Commissioner Hayward, any comments?
I have two sort of more logistic comment questions. Do we anticipate that when the Secretary of State's new online system comes online, that our research will be easier or change in some way?
Yes, we're hoping that since it's going to be a data-driven system, that we'll be able to search for patterns much more easily. And so we'll be able to really see what's going on in jurisdictions and who are the major donors at the local level as well as the state level. Because as you know, a lot of those aren't even online filings. So right now, it's a lot of running around and putting the pieces together and getting them into Excel spreadsheets. And we're really looking forward to, if the system delivers, then it's going to make these investigations a lot,
Okay.
I don't want to say easier,
Yeah,
but
well,
less
or-
time consuming.
Yeah, less time consuming and more accurate earlier and all those good things. And then I also recall that we have in the past, when there has been failure to file or failure to file completely in the course of an ongoing election, we've gone to court. Is that a cost-effective thing to do? When is that a good thing to do, and when would you not do it, I guess is my question.
Generally, we consider all of the factors, and the biggest factor being if they're a viable candidate. So if the information needs to get out before the election in order for the voters to make an informed decision, that's really what determines if we're going to try to get an injunctive relief to get the statements filed. We always go for 100% compliance. We have pre-election efforts every year where we contact the city clerks and the county clerks and they reach to a certain level and ask them to proactively send us the people that haven't filed, that have said that filed 501s with statements of intention and 410 saying that they're a committee, and either one of those, and they haven't filed anything before the election. And we spend a lot of resources making sure that all of those jurisdictions get up to 100% compliance before the election date, so that the information is out there to get the level playing field when it matters the most. But for the injunctive relief, we obviously can't do it in every case, and so we try to weigh it as to impact, public harm and impact, and that's where we spend our resources.
Thank you.
Any further commissioner comment? All right. So to recap, Chief of Enforcement West, I think you're hearing a consensus among the commissioners to continue using the criteria that you've presented to us, and that as part of our efforts to review and amend the enforcement regulations, which, well, pre-noticed in June, we will be looking at the criteria in 18361.5 subdivision D at a minimum to add comparable cases and sophistication of the parties, and also consider some changes to seriousness of the violation, among other potential changes. But that'll
Yes.
happen down the line.
And the only other thing I would point out that we do consider is level of cooperation. And that's something that you see in our stipulations, so I would just point it out that it's in there.
All right, thank you. So at this time, I think One of the areas that you presented on that I know commissioners are interested in hearing more about are your thoughts on potential changes to the Streamline program that we currently have. So perhaps you can take a few minutes and outline some of your thoughts on what we should consider going forward.
When Chair Madish asked me to do this, I immediately just started talking about, well, you know, this is what we found and this is what we looked at. And then I realized that Commissioner Wilson hasn't been along for the ride yet, and so hasn't seen all of the iterations of Streamline up to now. And so I'll give you a brief history if you'll bear with me. The Enforcement Division analyzes and processes over 2,600 complaints and referrals every year. And so throughout history, enforcement's grappled with a correct level of prosecution for the individuals and committees who violated the Political Reform Act, but have a lesser degree of public harm associated with their violation for a variety of reasons. And as early as 1999, enforcement proposed handling these cases through a streamlined procedure. And the fines were reduced and the settlements were more abbreviated in order to expedite them. Enforcement has successfully been managing the program since this time. And up until January 2019, the Streamline program only included campaign non-reporters and non-filers, SEI, statements of economic interest, non-reporters and non-filers, and lobbyist non-filers. And so what we did was we undertook this process to try and get a bunch of other things added to the Streamline program that fall into these criteria to help manage the caseload that's ever growing, that seems to get bigger every year. So at the January Commission meeting last year, the Commission adopted Streamline regs, and this is the first time we put them into regulations. And so we had to write very specifically how these things were going to apply and what we were going to do to follow them. At that time, the Commission stopped approving the settlements themselves as well and delegated that to me, and you see those in the executive report now.
What year did that?
That was last year,
Oh,
January.
last year, recent, okay.
Yeah. And in Oakland, I believe. So now that this program's been in effect about a year, enforcement is proposing revisiting the regulations to make some improvements, listen to some public comment as to how they feel has been working or not working, and some areas that we see could use some tweaks. So those areas I'll go through briefly, which you'll get to hear in detail when we present those for pre-notice. Modifications to two of the 24-hour report exclusions. While the intention was good, what we have found is that these rules disproportionately exclude some of the smaller, less than $10,000 worth of activity campaigns, because those are the ones that are most likely to miss a 24-hour report entirely. And it wouldn't be de minimis because their campaign is so small, and with the threshold being $1,000 for those reports. So we're coming up with some ideas of maybe a threshold or something to put on those to make them more effective. Modification of the population thresholds. The lower levels have been found to exclude the candidates in rural areas and smaller jurisdictions, so we propose collapsing some of the bottom categories. Adding to additional violations. Major donors are kind of their own animal under the act, and so it's been difficult to apply Streamline rules to them specifically, so we want to handle them in their own category. And I proposed some ideas for what we could look at the November presentation. And then behested payment filings. Those are also completely their own animal, and so we would like to find a way to deal with those in an effective way and really get some commission input as to how severe the commission how serious the commission thinks these violations are. Sorry. Since it's going to be excluded from the regulation, I thought maybe we'd use it one more time. But so it really we need to get a sense from the commission if these are appropriate for Streamline, and if there's some way that we can handle, because these are the reports that I'm sure everybody knows at $5,000 of behesting a payment as opposed to getting a contribution that the public official has to file these reports. And then modification of the 20% thresholds for reporting exclusions. Examples of the smaller committees that we have, and we have all examples for all of these, so we'll be able to give you some empirical data so you can see how this has been working. It seems to exclude the committees, I really don't know where that's coming from, but it seems to exclude the committees that kind of have all their activity on one statement. So you're a small committee, you just decided to run, and then you do everything on your second pre-election. And so the 20% thresholds of your entire activity will never apply to you. So we're trying to play around with some ideas on that. And then the reduction of the lobbyist maximum amount to participate in Streamline is currently $100,000 for a report. And what we have found is that includes everything. So basically, most of our lobbying cases, unless we can prove intent, have been falling into Streamline. So I want to discuss that and see if that's what we intended. And then amendment of the language to the advertising criteria. We have one criteria that the way that it's written about confusion to the voters is kind of subsuming all the other criteria. So we want to kind of make some modifications because that was not what we intended, to have one all-powerful criteria. And then increasing the base penalty amount for advertising violations. As you've seen on the agendas, the 100 plus 1% has really shown some very, very low fines for advertisement violations. And so I want to have the commission's consideration about raising the base penalties on those. So those are the areas. Hopefully I didn't speak too quickly, but I think that it really is a good time after a year of seeing how it's been implemented and making some of these tweaks and moving forward.
Just a question on the one relative to the major donors. Because major donors are supposed to be informed by the committees that receive the money from them, that they may have an obligation to file as a major donor. Where were you looking to draw the line? In other words, if they were supposed to be notified but weren't, they could be eligible for a Streamline, or is there some other?
I was looking at one of the slides that I presented. I put that the things that I've been thinking and trying to apply is the difference really between warning letter, Streamline, and mainline on where to draw the line on major donors. And then never filed before, filed after contact. Once they heard they had an obligation, they received no notice. Their activity was under $30,000, and the business itself is terminated. So those are the things that I have been considering currently when trying to decide as between warning letter and mainline. So I think that no notice, and if it's also their first time, I think weighs heavily.
Yeah. Okay, thank you.
Other commissioner questions or comments for Chief of Enforcement West? All right, well, we look forward to your proposal in the coming months on this. And then the final item under this category that I wanted to talk about today. Some time ago, the commission heard from the Enforcement Task Force when it was in existence about the concept of creating a public-facing portal where the public can actually get some very basic information on complaints and other pending cases and closed cases, which I think Mr. Waringa would probably appreciate, so that some information is more accessible to the public and they don't have to actually call him. So our staff has actually put together a demo of a beta for that type of a portal for us. And so I think if we take a few minutes, I think that'd be a useful bit of our time. Sure, we can take 5 while they're setting up the presentation.
Well, that's a good chance for me to find that little room.
Yeah.
Running a good meeting, Mr. Chair.
Oh, thanks.
Moving through the program.
No, I think it's the January.
Oh, keep doing what you're doing, I just.
Yeah, no, the January agenda tends to be a little bit lighter.
Oh.
It's just because there's such a short window between December and January.
That's what some of the staff said.
With all the holidays. It's just- So I think, I actually think hearing those 2 cases when we approved here, I think that's going to be a really good experience for all of us. I'm looking forward to
Oh,
it.
yeah. Yeah, I mean, it's just a lot. I mean, I knew what the FPPC did, but to see what's going on behind the scenes is fascinating.
Oh, yeah.
It's just,
So I'll just wait here then?
it just blows my mind.
Yeah. No, I think that's good. Hang on a second. Commissioner Cardenas, yes, we've taken a 5-minute break.
Oh, I see. Excellent.
But, I mean, every.
Commissioner Cartness and everyone that's on the phone, I just want to let you know that presentation that is being conducted by Enforcement Division on the case management portal will be displayed on our YouTube video. If you are logged into our YouTube video to watch our meeting, you'll see the full demo through that.
Excellent.
All right, we're back from our 5-minute break. We will go ahead and start the presentation on the beta of the public portal for case search. And we have Chief of Enforcement Wes and our IT department. Welcome.
Good morning. The second one is just our website. What we see in the future is bridging those two systems. So you click the link and there's no search needed by the user. It automatically pulls up whatever documents for that case.
That'd be step 2.
Great.
So they're working on that as well. And then the format, when you do the search, if you have the case number, it's usually for our case numbers, they start with the year, so 2019 dash and then a number. And Honest told me that we don't need the dash.
You can include a dash or without. come up.
Which is good, because anybody that's done a search on anything realizes that if you forget to add a dash or a comma and your search won't work, it's very frustrating. So it's great that IT has already included that to keep it for people like me from breaking the system. So
I'm impressed with what I've seen so far. If you put a search function in quotes, will it pull up that exact language? For example, if you type in, an exact name, first and last name, will it pull up that exact first and last name? And you know what I'm talking about when you do the
Yeah.
search with quotes.
That's something we'll have to test.
we're not sure yet. So far, the searches we've been doing have been trying to be more inclusive, because we were trying to make sure that we get all of the results, which in searches in the past that we've tried to have vendors implement has been an issue. So for us right now, we're doing over-inclusion, and then we'll make sure that the specifics also work. Is that correct?
Yeah.
Okay. And then we'll also be trying to do a link to the public records request email, so that when people want to get additional records, they'll be able to just push the link and make that request at that time. So it should be easier for people to put in the information. And then if you want to look at complaints. So this is where you would do any complaint search where Daniel's doing it by the year. You could also do it by the specific complaint number. And our complaint numbers are pretty easy, because they're COM dash and the date the complaint came in, and then the dash of county of the complaint numbers. So here you see you get the complaint number, the type of complaint that it was, the sworn, the referral, the status, whether it's an intake review or if it's case has been opened. Another thing you'll see is case combined into a case, complaint combined into a case. And then the jurisdiction, and again, the external parties. Do you want to show the filter and talk to them about that?
Yeah, so at the top of the screen here, there's a little box called filter. So if you were searching 2019 complaints and you wanted to search for a specific person or maybe even jurisdiction, you could. So we'll search by respondent. So maybe we'll do this first one here. So I can spell it right. So Vicky Gordon, anybody named Vicky, external parties would be within this. So it's basically like a search within a search. You're filtering down your results.
So you can't search just respondents or just complainants, right? It's just bring up both if Vicky was a complainant or
Correct.
respondent. So like I said, we're trying to be more over-conclusive and then having all the information out.
Can I give you an example of like a simplistic thing? Is that I'm searching for somebody named Smith, and I input S-M-I-T-H, but it's actually S-M-Y. Is anything going to come up, or is it going to be like at the library that you don't get it exactly right, you get nothing?
If you have more, like, let's say you put in Smith and you don't get anything, and then you're searching by jurisdiction because you know it's this year, there's other ways that you would be able to find it with a little elbow grease, as I say.
Yeah.
We run into this with media requests where they spell the names wrong. And I know media is 100% accurate all the time, but I know you're all shocked.
That's what they say.
Right. So we do run into that where we say we don't have anything, and then we realize it's spelled with an A-O instead of a O-A.
Google has this great thing that they politely say, "Did you mean?" and then they give this other spelling that's,
We don't have any functionality.
We don't have that right now, but we could look into it.
Yeah.
Thank you.
Yeah, and there are a number of websites, I think, the State Bar's website, for example, if you do a search and it sounds like a particular name, because it's an unusual spelling, it'll pull up similar sounding names. So there's various websites down the line which you could look into that.
Okay, yeah, we'll look into those.
Okay. That's all really interesting.
All right.
Thank you. I'm really excited about that. Really am. Thank you.
Yeah, no, great work. And again, this is just the beta version of this. I think as we refine it over time, it's really just going to get even better. Just a couple of things. First, I just want to clarify, this is primarily a mechanism so that the public can get a status update and basic information. This isn't a substitute for CPRA, Public Records Act requests for specific documents, particularly with respect to open cases. I know for closed cases, you can link to, the warning letter or whatever the final disposition is, but you will not, at least in this beta version, be able to get a copy of the complaint or correspondence between the parties, at least as we're rolling it out right now. So I wanted to clarify that.
That's correct.
Secondly, my understanding is we're going to be updating this at least twice a day to begin with. So there may, depending on when a complaint is filed in the course of a day, it may show up by the end of the day, or it may not show up until the next day, assuming we're in the period of time where we can publicly disclose the filing of that complaint. So it just may be that there's a delay for some records. And finally, my understanding is that we're going to also be adding for the filters a search function by violation type, so that if you want to search by, let's say, money laundering, you could actually specifically just pull money laundering cases as opposed to searching by the name or a jurisdiction, which I think is a useful thing for the public to be able to do.
Yeah, that's something we have planned.
All right, great. Any other commissioner comments? All right.
I would just like to point out, this was all done by our own internal IT staff, and which I just find amazing that they were able to do this and make it look like something that you would see on the internet that would function and work well. And enforcement will be adding all of the language with the instructions and working on making it to where you understand what the search results say, so that people don't call me and ask me what they mean. But so we will have really specific instructions and explanations as to what the results are.
One quick question. Will the starting point be 2019 moving forward, or will it include archived years going back to a specific date?
It's going to be everything that we have in our Salesforce database, which goes back quite a bit.
It's good from 2016 forward, and 2016 to 1999 is sketchy. There's been a lot of database turnover, the technical computer term. So 2016 forward is good data, and most of the fields will be filled and accurate. And I would say between 2016 and 1999 would be less filled in fields, as it was brought over from another system.
But it'll be there,
Whatever we have will be there.
Great. Well, again, I think this is a great way to improve transparency by our own agency and help out the public. So I think our plan is to have this out in February as a beta, and so I'd invite users, members of the public, fellow commissioners, other staff to continue providing input on ways we can refine this going forward. So.
I'm terrified but happy.
All right, thank you.
At least Jay now will get more informed questions.
Hope springs eternal. All right, thank you, guys. Moving on from item 12 then to item 13, advice letter report and commission review. Mr. Bainbridge, Mr. Lau. Do you have any advice letters you want to bring to our attention?
I do not. I'm here to answer questions if there are any.
All right, do commissioners have any questions or comments on particular advice letters? No? All right, take it as submitted. Thank you. All right, we'll move to the item 14 then, executive staff reports. The current order is enforcement, legal, admin. There was some question as to whether we should begin with the legal division report, though. So, Mr. Bainbridge, since you're already up there, why don't we begin with your report?
We'll let Galena catch her breath here. Yeah, I just wanted to highlight all the outreach and training we have going on. That section is longer this month than it typically is, just because there's an election coming up. So we've been up and down the state putting on different seminars. We were just in Glendale and Merced this week, which isn't reflected here. And then we have some upcoming in Salinas, Rancho Cucamonga, and Sacramento in the next month or so. So if people are interested, go to our website. If you're in those areas, take a look. It's all listed on our website on the training and outreach page. If there's jurisdictions that want to request a training of their own, as long as they can get enough bodies there to make it worth our while, we'll come and as long as we have enough bodies to go down there, we will, or up, I should assume it's going to be down. We will try to accommodate any requests we have. And then there's also video tutorials online. So especially if you're a new candidate or treasurer or need a refresher on the rules as a candidate or treasurer and you can't make one of our live tutorials, there's one online with a video with TV and radio's own Jay Allen narrating it. So it's worth listening just to hear the voice. But it has some really great information. We also have all the printed materials that are on our website. So for all those new candidates and treasurers out there, go to our website. You'll find whether you're an audio learner or you like to read things, there's information there for you to figure out what you're required to do. So beyond that, just highlight the great work that our training and outreach people are doing.
Great. Thank you, Mr. Bainbridge. Any questions for General Counsel Bainbridge? All right, thank you. Chief of Enforcement West, welcome back.
Thank you. I would say along the lines of what Dave was saying, there's also a new candidate fact sheet that is on the website that enforcement staff, Chloe Hackard and Dominika Wajenska, worked on and had a lot of input in to give to the legal division to make sure it was all legal and and correct and proper. And we have it up for this election cycle. So we think that that's going to be helpful for something for the clerks that can actually pass out when they come in and ask information of the clerk. So we're excited about that. It's something that we're going to also be sending out with the pre-election efforts. So remind the clerks that they can use this as a handout. So it's for local candidates. It's nice. And then the other big thing I would talk about is we closed 209 cases in December as a division, which is great. We average about over 100 every month. And so in December, we did the big push under the year to get rid of everything that needed to be closed out. And so the cases with resolutions approved by the commission is another record-breaking year for us. So it's 343. And so we continue to keep trying to get those cases before the commission and get those moved as quickly as possible. And 584 warning letters were issued last year. So Enforcement Division with the same amount of resources has been doing a terrific job. And I just thank them for all of the efforts in that final push of the year. I was very happy to see, especially with the election coming up. It was like, I didn't know how hard to push before the election. So I'm very happy that everybody's responsive.
Thank you. Any questions for Chief of Enforcement West? All right, thank you. All right, take our admin report. Ms. Hahn.
Part of the agenda that's admin have provided is the annual report, as well as the legislature report that we submit to the legislature every year. I would say submit it unless you guys have a question for me.
Questions for Chief of Administration?
And if you guys don't have questions on the annual report, I would like to highlight that this is done in-house by one of our super staff, Riego Avesca. She have put all of this, the graphic, the layout, everything on her own. So I just want to take this moment to thank her.
Thank you. Your staff did a great job on this. It looks really good.
Thank you.
And also, thank you for your work and Executive Director Jones in preparing the letter to the legislature. I know that took some effort too, and some we've been doing for the last 2 years, if memory serves. So I think great job on pulling that information.
Yes, this is year 2.
All right, thank you. All right, and last but not least, Executive Director Jones.
I get a bat cleanup, just a couple of updates on things. Following the commission's instruction at the December meeting, I submitted a request for a feasibility study by Post for the Enforcement Division to get their investigators some type of modified peace officer status. I called them this morning. They are actually meeting today on it, which surprised me, and they say that it's the only study that they have in-house right now, so hopefully they'll be able to move forward quickly. The plan, I think I mentioned last, in December, the legislature won't enact legislation without the feasibility study in hand. But my hope is that we can get it done in a fast enough timetable that we can do it during the legislative session and hopefully make a pass at them if we get it done, so that we can make it a 1-year instead of a 2-year effort. Update on contracts. We've had a couple of municipalities take their contracts or are taking their contracts before their governing bodies this month. We are hitting a little bit of headwind with a lot of the smaller communities. A lot of the smaller communities really want us to take it over because they don't have the local expertise in it. And we are having sort of a hang-up with regard to the budgeting and how much we need to charge so that we're fully staffed. So you may hear me come back to you next month with sort of a status on that and what we might be able to do in order to encourage more small municipalities to hire us for our expertise. Other than that, I'm happy to take any questions, but that's all the updates that I have for this month.
Just a question on the legislation that's, with the default campaign contribution limits. Have you gotten any inquiries at all about how that's going to affect them, or whether they that would push them towards contract administration?
I have not gotten any. I did get an email from one small municipality asking how that jibed with the contracting process, because it was the first time that they had ever sort of experienced that type of clarity on their contribution limits. And I placed a call when I got the email. I have not heard back from them.
Thank you.
Sure.
Thank you. All right, moving on to our final item, commissioner comments, proposed future agenda items. Do commissioners have any concluding comments or comments on future agenda items?
No.
I found what I was looking for in the legal report, so I'm good.
Commissioner Hayward? All right. Commissioner Cardenas, anything?
I just want to thank staff. I see that for our next meeting in February, we shall be taking up, or we may be taking up, for consideration actions with respect to limited liability companies, and I think we're all looking forward to that.
Great, thank you. We are. All right. Well, with any final public comment? Seeing none, do we have a motion to adjourn?
So moved.
Second.
All right.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Commissioner Wilson?
Aye.
Chair Matich?
Aye.
Motion passes.
All right, thank you, everyone.
So what time you're heading to the airport about what time? Yeah, you go about 2 or something like that? Yeah.
So I can go now.
Thank you.